Greetings. Hello and welcome to Me Our Conqueen, a platform dedicated to meaningful conversations on alternative dispute resolution and its growing relevance in today's legal and social landscape. I'm delighted to have you with us for today's episode, sir. At Me Our Conqueen, we strongly believe in promoting peaceful, efficient, and collaborative method of resolving disputes with the aim of resolving excessive reliance on litigation. While the judiciary plays a crucial role in delivering justice, courts across the world remain overburdened with cases, many of which involve minor disputes, interpersonal conflicts, or matters that could be resolved more effectively outside the courtrooms. Alternative dispute resolution mechanisms such as mediation, arbitration, conciliation, and negotiation offer a constructive way forward. ADR not only help in saving time and costs, but also preserves relationships, encourages dialogues, and empowers parties to participate actively in the resolution of their disputes. By resolving appropriate matters outside the courtroom, ADR allows the judiciary to focus its attention on complex and serious cases that truly require adjudication. Through this platform, we aim to create awareness, spark dialogues, and strengthen trust in ADR as a first choice mechanism for justice delivery. At Me Our Conqueen, we have wholeheartedly embraced the transformative potential of alternative dispute resolution and brought it to life through this dedicated podcast. This platform goes beyond delivering insights, it serves as a dynamic bridge connecting ADR professionals, practitioners, students, and enthusiasts across India and beyond. Our objective is to foster greater awareness, deeper understanding, and stronger preference for ADR as a trusted and effective method of resolving disputes. Driven by our mission to position ADR as the first and foremost choice for conflict resolution, each episode features thought-provoking discussions, expert perspective, and real-world success stories. Though these conversations, we highlight how ADR resolve disputes swiftly, amicably, with lasting impact while strengthening access to justice. Before we begin, a brief introduction from my side, sir. My name is Summi Roy. I am a final year law student at Asian Law College, Noida, and I am currently intern at in ADR. It's a pleasure to be your host for today's episode, sir. Guest introduction. Today we are truly honored to host Mr. Sanjeev Nirvani, sir, a distinguished legal professional with over 32 years of expertise in alternative dispute resolution, consumer and commercial laws. Over the course of his career, he has served as counsel, arbitrator, mediator, adjudicator, and consultant in commercial matters, working alongside eminent members of the judiciary, including retired judges of the Supreme Court and the High Courts. Mr. Nirvani's extensive sectorial experience covers construction, FMCG, insurance, medicine, telecom, and power. He specializes in conflict avoidance, formulating effective business solutions, and achieving substantial saving in terms of cost, time, and resources for his clients. His approach integrates strategic project planning with practical pleading and documentation for complex disputes. A trained and certified mediator, he has actively participated in both national and international dispute resolving forums. His notable engagements include contribution to coveted moods like WIS, JESUP, FDI, International Maritime Arbitration, Deccan International, AIADR Mediation, MediateWise, Mediate Guru, Asia Pacific Commercial Mediation, and several other mediation initiatives. His involvement extends beyond practice as he regularly mentors and coaches emerging legal talents and serves as a judge in prestigious moot court competitions. Committed to promoting excellence in dispute resolution, Mr. Nirvani combines legal acumen with a practical result-oriented mindset. His long-standing dedication to ADR and his proven ability to navigate complex disputes make him a sought after expert in the field, both in India and abroad. We are delighted to have him share his insights and experience with us today. Permission to start the podcast. With your permission, Mr. Nirvani, may we begin today's conversation?
Yeah, Sumi, thank you for the elaborate introduction and let us begin.
Thank you, sir. Okay, sir. So, first question. How is ADR different from traditional litigation in terms of resolving disputes?
Okay, the first and foremost bright feature of ADR is that ADR is party driven, rather driven by party autonomy.
Right,
Uh,
sir.
Civil litigation in litigation otherwise, it is for one party to file a case and the other party has to appear.
Right, sir.
If you go by arbitration, that there has to be an arbitration clause in the agreement, or both parties have to agree to arbitration. And the same goes for mediation, conciliation, and
Right, sir.
negotiations. So mainly, ADR is party autonomy, which does not
Right, sir.
appear in litigation.
Right, sir. Okay, sir. So, sir, my second question is justice only about winning cases or about resolving disputes?
Justice has, aims to resolve the disputes, but it depends on the forum being used for resolving the dispute. Because
Right,
in
sir.
litigation, it is all driven by the courts, be it civil procedure, be it criminal procedure.
Right, sir.
So it necessarily does not mean that we might get uh, a resolution of the dispute. It will be rather winning a case for one party and losing for the other. Whereas when we go in for ADR, it is because of its party autonomy, most of the time
Right, sir.
it results in resolution of the dispute instead of someone winning the case.
Right, sir. Right. Thank you so much, sir, for such a valuable answer. Third question, sir. In what type of dispute do you believe ADR is more effective than litigation and why?
ADR would be then we have to now when we are talking specifically of ADR, we must segregate arbitration and mediation. Conciliation is
Right, sir.
not the conciliation act, part is not generally used. So in mediation,
And
uh,
arbitration.
no, can you come call the question again? Let me see this.
So, yes, I'm repeating. In what type of dispute do you believe ADR is more effective than litigation and why?
Okay. Now in arbitration, there is always the arbitration clause most of the time.
Okay, sir.
So there has to be arbitration. By law, there cannot be a litigation direct.
Right, sir.
So it has to be there. So we cannot say whether it will be effective or not. But yes, arbitration is effective in um, so many aspects.
Right, sir.
And
As you said,
we,
sir, third and fourth question are similar, like ADR in civil, commercial, family, and matrimonial disputes. Right, sir.
okay, now probably by law, I don't think family and matrimonial disputes can be resolved by arbitration, but by mediation, yes. So I would say arbitration would, I mean, most of the time be used in commercial matters,
Right,
and
sir.
mediation would be good for civil, family, and matrimonial matters. And we
Well
have
said,
seen
sir.
very good results in both.
Well said, sir. Like arbitration matters mainly for family and matrimonial
No,
matters.
arbitration mainly for commercial.
Sorry, sir. Mediation matters mainly for family and matrimonial.
Yes. Although
Thank you, sir.
mediation can work very well in commercial matters also, we have seen some good results. But generally, mediation happens only when both the parties are willing to give up something
Right, sir.
to attain peace of mind and quick resolution.
Right, sir.
So when it is a commercial matter, it's a matter of money and business. So it is
Right, sir.
difficult for parties to give up something. So uh, that is why in commercial matters
Arbitration.
might not see so much of mediation, and
Right,
arbitration
sir.
is the best thing to do.
Right, sir. Thank you so much, sir, for such an informative answer. And next question is, do you believe the future of law lies in dispute resolution than dispute adjudication?
Definitely, because there are so many features separately for arbitration and mediation. When we talk of arbitration, we can have a domain expert as a arbitrator, which generally we will not find in civil courts, though we have now, we are having commercial courts and the judges are specially trained on commercial aspects. Yet,
Right,
in even in commercial aspects, we have so many broad features like construction,
right, sir.
oil and gas disputes, which the um, our judges are not specially trained for it. And in arbitration, we could even have a engineer as a arbitrator who will be
Right,
knowing
sir.
the nuances of the dispute. So that will be good for that. And in mediation, we have trained and certified mediators, and I have seen some wonderful results by some very good mediators who are able to make, help the parties agree to a very good resolution and mediation
Right,
settlement.
sir. Right, sir. Thank you so much, sir, for such an informative answer. Next few questions, short questions I have prepared. May I ask, sir?
Yeah, sure.
Okay, sir. Thank you, sir. So, what skill should young lawyers develop for ADR practice?
Okay, now for ADR practice, young lawyers must first train with either with mediators or arbitrators or in offices having arbitration practice
Right, sir.
and to learn the nuances and uh, the difference between the civil litigation and
Right,
the
sir.
arbitration or how to deal in mediation, because the mindset and the mediation, you don't argue. Mediation,
Right,
you
sir.
generally present your case
Present.
and then negotiate or maybe agree. But so young lawyers must not straight away aim for becoming an arbitrator or mediator. First, maybe 2 or 3 years, learn how it is done.
Right, sir.
Just getting a 40 hours mediation training will not make you a very good mediator.
Right, sir.
Observe and learn from the actual sessions of arbitration and mediation. And yes, I have seen some young arbitrators doing very well as arbitrator and some young mediators also doing very good. But I believe they had learned from attending the sessions.
Right, sir. Well said, sir. Next question, sir. How does ADR protect relationships?
How does ADR protect?
Relationships.
Relations. Okay. This will be very good when we are talking of mediation, because in
Right, sir.
mediation, both the parties arrive at a settlement of their own, helped by a
Right,
mediator. So when
right,
the
sir.
parties arrive at a settlement on their own, discussing, negotiating maybe with the help of a mediator, so the relation can continue further.
Right, sir.
Unlike litigation or arbitration, where one party is handed a favorable judgment or an award, the other party might not feel as good. As in mediation, where
Right,
both parties feel more satisfied as compared to the litigation or arbitration.
right, sir. Right, sir. Well said, sir. Thank you so much for such an informative. Next question.
Yeah.
Is ADR less stressful for parties than litigation?
Mm, Mainly, yes, most of the cases. One thing
Right, sir.
is uh, the time of appearance. In arbitration and mediation, you can have some fixed time which necessarily need not be 10 a.m. In
Right,
litigation,
sir.
it has to be 10 a.m. Sorry. So that takes some load of their schedule. It can be on a holiday also in
Right,
arbitration and mediation, whereas the litigation has to be on court
right,
working days only. And then
right, sir.
arbitration and mediation are in a more informal atmosphere, like sitting across the table. Whereas in litigation, you have to be in a formal atmosphere, like court-like atmosphere. So yes,
Right, sir. Right, sir.
ADR would definitely always be less stressful.
Right, sir. Well said, sir. Thank you so much, sir. Now, sir, before we conclude, Mr. Nirvani, we would love to hear one advice from you. That is, what advice would you give to young lawyers on balancing the goal of winning cases with the responsibility of resolving dispute or conflict effectively?
Um, Young lawyers, I don't know. My advice is don't go straight away for money.
Right, sir.
First, first, first and foremost thing when a prospective client approaches you, discusses, you must advise the client to resolve by mediation, or rather not go in, have a conservative approach to dispute,
Right, sir.
not go to the court. I know
Right,
it might not bring money for you, but definitely that client will definitely come back to you,
right, sir.
maybe for another case which might be more pocket friendly for you. So don't run
Right,
after money, at least in the beginning. Try to
right, sir.
understand the problem, give suggestions for resolution other than the court, and do not just push the client into litigation just because you are to get money.
Right, sir.
Um, that is pretty much. I mean, at this stage, that is enough. Don't run after money. That is the first thing to do.
Well said, sir. That young lawyers do not jump into money in starting.
I know they are raring to go. It is desirable to get money. You have the pressure, 5 years of spending so much
College.
money of your parents in
Right,
education,
sir.
and you would definitely want to make it good. But to make a good advocate, it is not about
Right, sir.
straight away going to litigation and fighting. It is
Right, sir.
about good advice to the client and
Right, sir.
achieving result maybe without even going to the court. So that brings you long-term fame and money.
Right, sir. Well said, sir. Well said. Thank you so much, sir, for such an informative answer. Uh, thank you so much, Mr. Nirvani, for taking the time to join us today and sharing your valuable insights and experiences. Your work and dedication in ADR and justice continue to inspire professionals and students alike. To our listeners, thank you for tuning to Me Our Conqueen. We hope today's discussion encourages you to reflect the power of dialogue, collaboration, and alternative pathways of justice. Until next time, stay engaged, stay informed, and continue believing in peaceful dispute resolution. Thank you so much, sir, for joining us today. Thank you so much.
Thank you, Songmi. Thank you for hosting me.
Thank you, sir.